And welcome all to our first Lunch and Learn, an ongoing series. Our next Lunch and Learn is scheduled for April 20th, and the topic will be 1031 exchanges. Please allow me to introduce Mark A. Cuthbertson, Esquire, as a panelist for today to discuss subleasing and lease assignments. Mark is a prominent attorney with offices in Huntington. He received his Bachelor of Science degree at Villanova University and his law degree at Albany Law School. Mark concentrates his legal practice in commercial real estate, land use, the representation of municipalities in Article 78 proceedings, and other litigation related to eminent domain, civil rights, and labor and employment law. He has extensive litigation experience in both state and federal court at the trial and appellate levels, had tried numerous cases to verdict. Mr. Cuthbertson has been a councilman for the town of Huntington since 1998. Prior to that, he served as an assistant town attorney and planning board member for the town of Huntington. Mark also has many published opinions and articles and has also lectured extensively throughout his career. So please all welcome Mark to our Lunch and Learn series. Mark, please take it away.
Thanks, Leo. Good seeing you. And good, thank you for everyone who's participating in Lunch and Learn. I'm looking forward to when we can get back to normal and do this in person, but happy to do it online. My information is there anytime, and my email is at the end, but you can go on my website. If there are questions that, generate as a part of this and you think of them later, feel free to email me. I'm happy to answer questions you might have after the fact. So topic is assignments and subleases. I picked this topic and wrote something about it for CIBS a couple months ago because we've seen, an uptick in this. In my private practice, I do a decent amount of commercial leasing and certainly have seen this topic come up a lot more lately. And you're seeing it obviously in the industrial office and retail market. I will say, having just completed a sublease for a decent sized piece of space in Hauppauge, that subleases certainly can be even more time consuming than a prime lease because it requires you to review the whole prime lease, get comfortable with it, and then pull together a sublease that incorporates a lot of the prime lease and puts those obligations on the subtenant. I think I'm probably insulting people's intelligence, but in this context with subleases, we speak of the prime lease, which is the lease that the tenant and the landlord have, and then the sublease, in which the tenant is the sublandlord and the tenant in the sublease is the subtenant. So we're going to refer to that throughout this and wanted to make that clear. I'll say that much like a dysfunctional family, if you have a dysfunctional relationship with your landlord or your tenant, it is very unlikely to get better in a subleasing or assignment context. Landlords and tenants don't generally see the light and have a new take on each other. So if you have difficulties as a part of your relationship, you can anticipate that you're probably going to have difficulties if there are discretionary issues in the assignment or the subleasing. So for example, if you want to propose a subtenant whose use is a little different than yours and your landlord isn't cooperative, they've got a major piece of leverage there. And they can probably make your life difficult with that when it comes to the use clause, any of the other particulars of the assignment clause, which can often be the issue of recapture, which we'll get into later, and any profit split that comes from a sublease that generates a profit. And if there are issues that address that, you may run into difficulties with your landlord. I will say, a recent matter for me that came up that I found interesting when it came to an assignment issue was a laundromat where an equipment lender, obviously the laundromat is very much driven by equipment and it's expensive equipment. And the lender at the outset told the tenant that they needed to approach the landlord and get them to agree that the lender could find a replacement tenant. And my client, the landlord, was very, very hesitant to do that. But after seeing, how that dovetailed with the tenant's rights of assignment and how it made sense for this lender, because they were probably better able as a lender of this type of equipment to find a replacement tenant, they finally got their arms around it. So it was an instance where you wouldn't think assignment would be an important issue at the outset like that, but it was. Sublease and assignments are an exit plan for a tenant from the lease. The alternatives for a tenant who's not doing well obviously are a workout with the landlord if there's some sort of accommodation that can be made on space or on rents. The other is for the tenant, obviously, to default, and bankruptcy is always an option. The time to think about assignments and the ramifications for the tenant and the landlord are really in that prime lease. So I think it's something that it's easy to gloss over. If a tenant's in a hurry to get into a space, and we find that so often, they found the space, they have a lease, they don't want to fight about issues. And there are definitely, from a tenant perspective, which we'll get into, there are issues worth fighting about, because if you fight about them now or negotiate, I guess the better word, you will find some economic benefit down the road by taking the time to do this. And, that's a product of who you engage to do that work. As someone who mostly represents landlords, I will tell you, I come across probably what I would say are three types of attorneys when it comes to representing tenants. One is the sophisticated tenants attorney, maybe a larger firm that understands leasing, and they're really going to dig in, especially in the context of assignments and subleases, which are probably one of the more heavily negotiated areas of a lease. That in that instance, that attorney's going to try and create value for their client. The other end of the spectrum is the matrimonial attorney or the criminal law attorney whose friend has gotten a lease and dropped it on his desk and says, "Can you do me a favor?" So that's the lawyer, as a landlord, that I love, as a landlord's attorney I love, because there's probably going to be 2 or 3 comments at most. They're going to add the word reasonably wherever they can. And it's an easy negotiation, but it ends up really strengthening the landlord's position, particularly if the landlord has a form of lease that is in its favor. Listen, there are few landlords that don't have leases that are strongly in their favor, some far more so than other. And if you don't negotiate on those points, your client is left with the benefit of that bargain. So, and then in the middle is the attorney who might not do this all the time, but has a good handle on things and tries to issue spot, and you deal with that. So an assignment as opposed to a sublease. Sublease, as we said, and an assignment or an exit plan. An assignment is a transfer of all of the tenant's right, title, and interests in the lease to a third party who assumes all of the tenant's obligations. Sublease is not that. Sublease is a lease by the tenant for all or part of the premises. It creates an ongoing relationship under the sublease between the sub-landlord, who is the tenant in the prime lease, and the subtenant. Neither transaction terminates the prime lease, but the sublease creates a new substantive agreement with regard to the lease premises or a portion thereof, which is now subject to the sublease. Assignment is a full transfer, and it creates a legal relationship between the landlord and the assignee. There's no remaining tenant interest. The tenant is out of the way. The obligations under the lease run to the assignee, who is now the new tenant. Now, with that said, the landlord often, in the case of an assignment, requires the assignor to be to still be held under the lease. So they essentially stand as akin to a guarantor. So the person who has assigned the lease, the original tenant, they don't have the legal relationship anymore. But if there is a default by the assignee, then the landlord is going to look to the tenant, the original tenant. And I will tell you, the question comes up. 2 questions come up which is, why would a landlord or a tenant want a sublease versus an assignment? And what are the circumstances in which a landlord will allow a tenant, the assignor of the lease, to get out and not have to give that guarantee? Starting with the second question, I'll say that, you know, in that instance, it's few and far between where a landlord lets the original tenant out. They want them on the hook unless the assignee is much better looking than you. So if they're Apple or they're Google or they're a great credit tenant and you're just an average person, most landlords are going to want you to stay in. If they're much better looking than you, maybe under those circumstances, you have a chance that they'll let you out and you won't be guaranteeing those lease obligations. As we said, sublease is an ongoing relationship from the prime tenant, sublessor, and the sublessee. It's similar to a lease. Sublessee pays the rent to the sublessor or sublandlord and performs the obligations that are there under the lease. The big issue with a sublease is it doesn't create a legal relationship between the prime landlord and the subtenant. So they're not in a legal relationship. We'll talk later. There may be some recognition of that relationship, but the subtenant's going to pay the sublandlord rent. If there are things that need to be done under the prime lease, so for instance, there are roof leaks, and the subtenant is complaining about those, what they're able to do is go to the sublandlord and say, hey, you've got to go to the prime landlord and fix my roof. And it adds another layer into the relationship. You know, from the prime landlord perspective, for them, it's good because they don't want to deal with two parties, right? A prime landlord wants to deal with their original tenant, the sublandlord, and all of the relationship flows to them. They still want their lease under the prime lease. They still want the sublandlord / tenant to meet all of their obligations, and any of the issues between subtenant and sublandlord are on they're between them, and the landlord need not get involved. Assignments, in terms of whether something is full or partial, an assignment is always a full transfer of tenant's rights under the lease. There's no partial assignments, but there can be some instances when certain rights are reserved or delegated. You don't often see that. Sublease, obviously, not obviously, but it can be full or partial. So the sublandlord can stay in a portion of the space, or it can let go of all of the space. And then there are all sorts of issues that obviously come up in a partial sublease in terms of if there are, you know, CAM obligations and, you know, who has what proportion and who's doing what, you know, what are the obligations. So I would say that a partial sublease probably is a little more complicated, but, you know, not markedly so. Full sublease is very much similar to an assignment because the tenant is no longer physically present. However, the prime lease is in effect. And as we said, there's a separate agreement between sublandlord and subtenant. In an assignment, the assignee will be primarily responsible for all of the lease obligations. So in an assignment, the landlord is recognizing the assignee as the tenant and is responsible for, the tenant is responsible for performance obligations on the lease, as is the landlord to the assignee tenant. Sublease is usually accompanied by a separate prime landlord consent, which recognizes the sublease. So when you're done negotiating your sublease, you will would go to the prime landlord with that, and at that point they would issue a consent, and the consent often has some other obligations, so they'll want subtenant and sublandlord to sign off on it. A consent can be as simple as 2 sentences that the prime landlord consents to the sublease between, you know, XYZ company and the other company. Or in the case of more sophisticated landlord, it's probably a 4 or 5 page document that has all sorts of caveats and things that protect their interest and restate the various things that happen in that relationship. So the other issue I see and aggravates brokers, but most sophisticated prime landlords want a fully executed sublease before they will look at it. So they're not going to look at and give you feedback on this subtenant. Now, I think the brokers on the credit of a subtenant, I think that sublandlords will look at that and say, okay, I'll look at whether this is a credit tenant and whether I would accept them, because, why go through the exercise if this proposed subtenant, their credit is so far inferior and they're not going to be acceptable for that or any other reason, or if you have a variance in the use, so your use clause in the prime lease and what is intended in the sublease is different. A reasonable landlord is going to give you feedback on those things. What a reasonable landlord is not necessarily going to do is take a look at a draft sublease and give you feedback on that. They want it fully executed, not subject to any other changes, before they're going to have their lawyer, because they're, in almost every instance, the prime landlord's lawyer has to review the sublease, and they're going to charge the tenant for that, or may get passed to the subtenant, the sublandlord or the subtenant. But they don't want them spending a lot of time on the back and forth with that. So that you'll normally get a fully executed sublease is what is required. A big issue, I've said it 3 times already, I'll say it again, but the big issue in subleases is there's no privity of contract. You have to look to the subtenant has to look to sublandlord. The risks of an assignment or sublease to landlords and lenders, one of the initial risks, obviously, is that the assignee subtenant is not as good a tenant, either from a credit standpoint or performance of its obligations. Depending upon the way the assignment clause in the prime lease is worded, you may have the ability to object to that if their credit isn't as good. Normally, there is a mention of what the credit of the proposed subtenant will be within certain standards. The other issue is if their use is different, and how does that impact your prime lease? And the other issue, of course, and this is always, not always, but you see this and it has a big impact, is if it's the sublandlord or the tenant in the prime lease has the ability to assign their lease and it's a way below market rent, that gives them a lot of flexibility and leverage, and the landlord can really get stuck in that situation. I've seen that with restaurants where you'll have someone who's party to a restaurant lease, a tenant on a restaurant lease, and it's a way below market lease, and they'll try 2 or 3 other restaurants to come into the space because there's value in that. They're going to sell the business and they're getting money back for the value, that it's a below market lease, and it creates a real bind for a landlord. Landlord and lender risk mitigation strategies. If you're representing a landlord or a lender, how can you mitigate risk? Obviously, for the lender standpoint, it's important to have an SNDA, subordination, non-disturbance, and internment agreement for the lender that puts them in a direct relationship with the tenant and allows them it has benefits to the tenant, but it also has significant benefits to the landlord, which we'll talk about in just a minute. So the risk on the landlord side is that if your consent isn't required, which is extraordinary if it's not in a lease, but there can be if you don't consider it. If your tenant has a freely assignable lease, that's a tremendous risk to you because you don't know what that tenant is going to be like, how that fits in with your overall plan for your strip center or office. The best situation you can have for a landlord, which is not common, is that any assignment or sublease is in the landlord's sole discretion. So they can turn it down for any or no reason, but not common. Most tenants are astute enough to negotiate at least that consent will not be unreasonably withheld. Landlord in turn is going to want criteria on credit and other things when it comes to subtenant. Another risk mitigation strategy for a landlord is to have a very strict use clause. So the use clause gives the landlord a lot of leverage if there is a subtenant that comes along that's not exactly the same use, that they can object to that and create issues for the tenant. The other issue that gives a tremendous amount of leverage is recapture. And recapture is a provision in the assignment or sublease clause that says the only way that you're allowed to propose an assignment or sublease is to first propose that the landlord can take the space back. And not as uncommon as you would think. Tenant, if they're smart, really pushes back hard on that. But, I've seen it plenty of times, and you literally have to go through the exercise of agreeing to terminate the lease, which may work for you as a tenant. If you want out and that's your exit strategy, that can work. And if the landlord doesn't want to be bothered with your subtenant, great. Hopefully there's some level of communication before that you're not going through that exercise. I think I'm going to skip the last part of that. For lender, the SNDA really helps them in its risk mitigation. I know not a lot of people work for lenders out there. Subordination agreements are something that you would get as a part of. So a lease normally has a subordination clause that requires a tenant to enter into an SNDA with a bank, which says that, okay, my lease is going to be subordinate to the bank's mortgage, which is important from the bank standpoint. Non-disturbances, the tenant's not going to be disturbed, that they're going to be able, in the event of a landlord default or foreclosure, to stay in the space. So that's something of value to the tenant. And then attornment, which is that the tenant's going to agree to live by the terms of the lease. So from a tenant standpoint, risk mitigation strategies is to have limits on landlord consent and to have exceptions for affiliates. So if you have a sale or you want to transfer to an affiliate or an affiliated entity, that you're able to do so freely or subject to a test. From tenant standpoint, obviously you would like to get that the consent is required. If consent is required, it can't be unreasonably withheld with as few a number of caveats as possible. As a tenant, you try and negotiate in the first instance that you're going to be released if there's a sublease, particularly if you're proposing a more credit-worthy tenant. Not common to see, but you never know. And a recognition agreement, which is something, let me describe. A recognition agreement is something in the context of a sublease where a prime landlord recognizes the subtenant as a tenant, particularly in the event of a default, and they take over in that instance. So in terms of a tenant mitigation strategy, if you can get a landlord, the prime landlord, to agree to a recognition agreement, what that means is, that's an automatic mitigation of damages if you were to default. So there's a recognition that that tenant belongs in the space and that they, any of the lease payments that are there would mitigate damages. Risks of sublease to subtenants. The main risk is a lack of privity, which we described with the landlord, with the example of a leaky roof or any other thing. Sublandlord defaults under the lease. Well, two things. If the landlord defaults under the prime lease and it's impacting the subtenant's only remedy is to go to the sublandlord and ask their help. The other risk that there is in a lack of privity and a lack of a legal relationship between the landlord and the subtenant is that they, if the sublandlord were to default, ultimately the subtenant could be evicted through no fault of their own. So the subtenant might have, in a partial sublease or in a complete sublease, obligations that it doesn't meet. Landlord begins an eviction proceeding, and the subtenant, through no fault of their own, can be evicted. And obviously, contextually, you know, if a landlord likes the subtenant, it's not going to be as much of an issue. They'll probably recognize them and work out a deal. They don't like the subtenant, or they have other, you know, designs on the space, or there's, you know, for whatever reason, they don't like the subtenant, then the subtenant's out of luck. And now they've got to deal with this through really no fault of their own. That's why a recognition agreement, if you can get it as a subtenant, is something that would be great. If you can't get that, from a subtenant standpoint, if you can get that if you can get, and you probably should put this in the consent, that if there's a default by the sub landlord, you're going to get notice of that, and you're going to have the ability, but not the obligation to cure. So that's something that I would want to negotiate in if I were representing a subtenant. Recognition agreement I discussed already is the best of all worlds, but you know, a lot of landlords prime landlords don't want to give that, because I don't want to recognize two tenants in the building. I want to deal with one person. And you know, for a variety of reasons, landlords don't necessarily like to recognize subtenants. You know, obviously all of this is contextual, you know, in terms of the leverage of a tenant, leverage of a landlord, leverage of subtenant. So, you know, a really good subtenant that has some leverage and is looking at other space and is not in a hurry, all the other things that you see that create leverage for a tenant, you know, that's going to help their cause. You know, it's funny, because I'm getting tired of reading my slides here. I'll say that the context too of whether it's retail, office, or industrial, it makes a difference in terms of what is going to happen with assignment and subleasing. Because I tried to pick the brain of two friends who are commercial landlords who have you know, large retail spaces, and I said, well, what are the issues you see with assignment and subleasing to the retail folks? And they're like, we don't. Nobody assigns and subleases. They just leave the space. They leave overnight, you know. So unless they're a big retail tenant, you know, there's not a lot of talk about assignments and subleases in a mom and pop, or not even in a strip center where it's a mom and pop, you know, retail tenant or otherwise. They normally aren't looking to do that. They're just looking to leave the space, and they often do in the dead of night. Different in office. In the office context, this will come up more. And obviously in industrial comes up as well, where there's more of a negotiation. The assignment and subletting comes up. And just also, I mean, subletting, at least what little I've seen, there's a lot more sublet space on the market. I'd be curious when Leo comes back on. It seems that that's, you know, I've just seen limited instances, you know, the big ones that I've seen in the newspaper. So Newsday had moved from its big facility and sold that to Harts Mountain, right? And moved into, I forget what the space was. Maybe it was 80,000 feet. Probably not even that much, but COVID hit, and all of their reporters were working from home, and they said, "Oh, this works great." And all of a sudden they're subleasing out whatever the number was. Dealer Track, right? That big building in Nassau took that, and big space was going to occupy it all, and they're subleasing out a significant percentage of that. I have a good friend at MSC Industrial now. That's not a sublease, but same thing. COVID hit. People are working from home, and we don't need that office space anymore. I think they'll be out in the market for, you know, some much smaller space, but they sold their building. So you're seeing that a lot, and in the office market, you're seeing, and I think you'll continue to see. And I'm curious because this is not. I'm just a lawyer. I don't follow the markets, but it seems like you're seeing more sublease space that's coming online, and will continue to come online as people evaluate where they are post-pandemic, and people coming to either coming or not coming back to the office. Back to this, in terms of risk, subtenants, you know, subtenant, to the extent, again, like I said before, in terms of getting notice of default and performing obligations, if the subtenant can, maybe they may not get a recognition agreement, but they can get the ability to perform the non-monetary obligations of sub-landlord under the prime lease, maintenance, cleaning, security, so there can't be a default there, and it's in their own interest to assume those. That's a way of, again, mitigating their risk because of a lack of privity. Risk of assignment to the assignee. I mean, the biggest risk is that the landlord's just not going to accept the assignment. So, luckily an assignment is not normally a very involved document, right? It's just that, it's a page or two that says the rights are being assigned, not a lot of heavy negotiation. So in that instance, I think it's more likely that you'll get a landlord, even without a proposed assignment, to give an opinion on the tenant, whether they will accept them. This kind of dovetails and gets a little repetitive, so I'll run quickly through it. Landlord-friendly assignment and sublease provisions would include, broadly drafted, that any type of sublease assignment and any other means that are close to that would fall within the assignment clause. Any hypothecation, whatever the legal term is that they use, that's so annoying. Assignment will include corporate transaction, merger, and consolidation. That's usually an exception. But again, if you're drafting it from a landlord perspective, make it as tight as possible. Require requests for prior written consent from the landlord. If you can do it without any reasonable requirement, then that's good. Recapture. If I'm a landlord, I want recapture in there because that gives me a lot of flexibility when it comes to the space and the tenant. Tenants should try and fight hard back on that, but landlords, if they can get it. And then landlords and profiting from a sublease. You're seeing this now, maybe not seeing it in the office market, but certainly in the industrial market, that the rents are higher industrial in the proposed subleases than the prime leases. So, if I'm a landlord, I don't want the tenant to get any of that profit. A compromise on that is 50-50. If you'll get 50% of it as sub-landlord, and I get 50% of it as prime landlord. Most landlords like to dig their heels in and say, hey, I'm not in business with you. You're not my partner in real estate. I don't have a percentage lease with you. I don't care about your profits. You shouldn't care about mine. So I'm not going to give you any of the profits from that. Tenant-friendly assignment sublease considerations are consent not unreasonably withheld, free assignment to subsidiaries, eliminating recapture provisions, either a split 50-50 on profits, if they're, as a compromise. But if you can't get 50-50, you should, as a subtenant, get that any of your costs, brokerage, attorney, etc., associated with the sublease, that you can net that out of the profits, because you've spent now money to pay your broker for this sublease and pay your attorney, and you should at least be able to net that out of the so-called profits. Prime landlord consent, usually requires a review of subtenant's financial situation, and certainly a fully executed lease. Normally, I'd be curious to see if people have seen instances where that doesn't happen. I had a case recently where the real estate consultant was from out of state and thought it was absolutely absurd that a fully executed sublease was required to review a request. And I said, I've never seen a situation where it wasn't required. So maybe it's different in other parts of the country. A strong subtenant brings more leverage. I think that just says that. Coordinating the sublease and master lease. Term can't extend, obviously. Term of the sublease can't go beyond the prime lease, and that's something that normally, not always, is included in the sublease. In the event that there is a right to sublease, and that's dependent on a lot of factors, it can't be done in a manner normally that's going to contradict the assignment provisions of the prime lease. Whether you get a right as a subtenant to sublease, depends on a lot of factors, including how much time is left in the lease and how much strength you have vis-a-vis, as a tenant. So another way that you need to coordinate is that if there are defaults, you have to allow enough time that you would get notice as a subtenant within the cure periods for the landlord under the prime lease. So you would want to make sure you're doing that. Incorporating by reference, most subleases have a portion where essentially many of the provisions of the prime lease are put upon the subtenant, and they have an obligation as to them, or they're bound by them, whether it's insurance, indemnification, and all those other things. And then it carves out, maybe 10 or 15 paragraphs, rent, maybe term, other things that are peculiar to the relationship between sublandlord and subtenant. Yeah, we talked about privity like too much. So default mitigation strategies for a subtenant. We talked about this really. And that's it. And feel free to email me at mcuthbertson@cuthbertsonlaw.com anytime, if it's this context or another. I have tons of lease provisions and forms, or just happy to discuss this very exciting area of law with you at any time. I don't know what it is, but my practice is varied, but in the last year and a half, it's gone to like 30% leasing and subleasing. So it's fun. It's just, you really got to stay on top of it, because otherwise these brokers are all over you. Why isn't the lease out? Why haven't you commented to it? What are you doing? You're killing me. So you got to put up with the Leo Farrells of the world yelling at you that you're not turning things around quickly enough. But I do find if you do that and you are responsive, that, it's a satisfying area to work in, and the relationships are good. You just, like all things being a lawyer, have to be responsive, because people are making money. And if you're sitting around waiting to give comments or waiting to get a lease out, then you're hurting the other people in the deal. So that's it.
Well, Mark, I have to say that you may think it's dry, but it was a very thorough presentation, and it's attracted over 40 people for your topic. So I think you did a very good job.
Thank you, Christine.
If anybody has any questions, you can put them in the chat box, or you can put it in the question and answer box, which I believe that Mark and I can both see, but I'll read the first question that came in, or you can simply raise your hand, and then I think I can unmute you, and you can,
I see Dan.
Dan Wiener.
Yep,
Yeah.
that's the question. How far should broker go in terms of term sheet to detail sublease rights? That depends on, how important you think that's going to be to the sublandlord or the subtenant, or prime landlord or prime tenant. Yeah, I mean, if there are things that are important to you that or if you think there is I think the problem is that in the context of a prime lease, there's not a lot of thought into assignment and subleasing, because it's like, okay, everything's going to go great. We're going to be in there for 10 years, and we don't really give it a lot of thought. So, and I think if you sneak it into the term sheet, then it's hard for a lawyer not to abide by it, right? So if I get a term sheet and it has that the brokers have agreed that the tenant's getting XYZ right, or subtenant's getting XYZ right, vis-a-vis assignments, etc., then it's not really a talking point thereafter. So if you're forward thinking on that and want to create, what could be future value for the client, that's good, because on the landlord side, most sophisticated landlords make it as difficult as possible and criteria as tough as possible when it comes to assignments and subleasing, particularly by way of a recapture provision. That gives them a world of flexibility. So you should be as specific as you can get without, driving your respective client crazy.
Thank you, Mark. Does anybody else have any other questions for our panelist? If you have, you can raise your hand, like I said, or you can type in the Q&A box, the chat box. If not, Mark has provided you with his email address. You can contact him after the program. I don't see anything else that came in, so I guess you covered all points, Mark. So on
Amazing.
behalf of CIBS and our sponsors, thank you so much for your involvement in our Lunch and Learn series. We appreciate having you here today, and hopefully we'll get to see you in person again one day.
I look forward to seeing everybody. Thanks. Thanks, Leo.